last time I checked, we live in the United Kingdom, and largely we are a Judeo-Christian country. In fact, oh my gosh, I've cut my lip. Sorry about this, guys. But apparently, quite incredulously, a British Sharia council was given credibility by the High Court when a judge used one of its fatwas to decide a case. The Islamic Council, founded by hardline preacher Haitham al-Haddad, issued a religious ruling forbidding a health trust from allowing a brain-damaged child to die. Secular campaigners said using fatwas in civil courts undermined liberal democracy. Well, I get a tissue because I'm bleeding like a rugby player right now. Let's speak to Mohammed Amine, who's ex-chairman of the Conservative Muslim Forum. Mohammed, great to have you on. What do you make of this case that a High Court has actually used a fatwa in one of its rulings?
Good morning, Alex. First of all, this is not exactly hot news. This case was 5 years ago in 2019. And this morning, I downloaded the full 70-page High Court judgment. I went through it very quickly, of course, because I was short of time. The word fatwa occurs 8 times in 70 pages of legal opinion or legal decision by the judge. And how much do you know about the facts of the case? I can explain them very briefly. The parents were Muslims. The 4-year-old girl who had a serious brain problem. She'd had a blood vessel, I think, burst in her brain. And the hospital trust that was treating her wanted to switch off life support while the parents wanted her flown to Italy, where a hospital was willing to carry on treating her. And the parents, being Muslims, got a legal opinion from the Fatwa Council in Europe that as Muslims, they couldn't consent to having life support turned off. I mean, there are cases like this crop up quite regularly, whether people are religious or non-religious. And in this case, the parents wanted some kind of authoritative statement about their Islamic religious beliefs. As I said, the word itself was only used 8 times in 70 pages by the judge as he was going through it. And my quick reading is that it played basically no important role in the decision. I think this is a storm in a teacup by this journalist. It's a really poor quality article in the Times.
But should we be alarmed at all that a fatwa could be used in a court in the United Kingdom? Apparently we're sort of the leaders in Europe when it comes to having Sharia courts in this country. Is it right to have a parallel legal system, so to speak, that isn't founded in the laws of this land?
Well, let's first of all go back to what happened in this case. We have some Muslims saying that Islam says X, and it's perfectly reasonable for them to put forward some kind of authoritative statement from the Sharia Council about what Islam says. It's no different from a Roman Catholic getting something written down by a cardinal saying Roman Catholicism says this, or a Jewish person going to a Beth Din and getting the Beth Din to write down Judaism says this.
But in terms of having Sharia councils in this country, which we have quite a number of, is that appropriate? I mean, Fayaz Mughal, who's the founder of Tell Mama, an organisation which protects Muslims from hate crimes, he says Sharia councils are composed mainly of men over the age of 50 who have very little relevance and understanding of modern life. Their interpretations of Islamic law and their desire to keep couples together, even when there are serious problems in the relationship, do not recognise the safeguarding of women. That's sort of in the context of, say, Sharia divorces. But, again, I'll repeat my question. Is it right to have Sharia law in this country, which in many respects isn't the law of our land, or it's not in many respects, it isn't the law of our land, full stop, might contradict the law of our land, so you end up with a justice system that does one thing for one section of the population and something else for the other section? That isn't the same law for everybody.
Well, again, let's look at the facts. We have one law in this country, which is English law made by Parliament and made by judges appointed by the Crown. Quite separately, we have a system of Christian church law administered by Christian courts for very specific Christian issues. We have a system of Jewish law where Jewish people can go to a Beth Din if they got a disagreement between themselves and they want some kind of arbitration. And likewise, we have this Sharia system where Muslims want to get a private ruling, because these are not state-sanctioned courts. These are private arrangements where people of religious belief, if they have an argument within their religion, want an opinion. What's wrong with that?
Well, what's wrong with it is when it's being used inside a court in the United Kingdom. And also, some people might say that some of the rulings are just not appropriate in 21st century Britain. This is Britain. This is the way we do law. This is our, democratic right. We get to vote in Parliament, or we get to, vote for people who in Parliament decide the laws of this land. And there probably shouldn't be anything else other than that.
Well, let's take those. You said two separate things. Let's take them one at a time. The one about the High Court using the opinion of the fatwa as part of its decision making. That's no different from it using an opinion from a Jewish religious court, or using an opinion from, say, a Roman Catholic cardinal about what Roman Catholicism says, if that was relevant to a High Court decision. What is wrong with that?
Look, what I might say is people being treated differently in the eyes of the law based upon their religion probably shouldn't be the case.
The court is not treating people different based upon their religious beliefs. If somebody's religious views are relevant to a decision, the court is entitled to seek whatever guidance it wants and to take into account whatever information is available about that religion.
OK, let's take the example, let's say, of polygamy as well when it comes to Sharia. It's something that's allowed under Islamic law. People can download an app where they can write a will according to Sharia law, where they get to sort of, decide what their various wives all get. But in the United Kingdom, under our legal system here, if you're married to more than one person, that's considered an illegal offence. That's considered bigamy. Should there be two different types of law in this land?
There is one type of law in this land, which is English law. An English domiciled person cannot engage in more than one marriage without it being a criminal offence. And in cases, sometimes people from this country go to Pakistan, for example, and take a second wife, and actually they find themselves then quite correctly being charged with bigamy in the English courts. So the only situation where English law recognises more than one wife is if somebody is married already overseas in a country which has polygamy, and the family moves to the UK, English law will recognise them as still being married, all three of them, for example. But apart from that case, English law says you can only have one wife. I don't see what you're talking about as a problem.
OK, well, let's go back to the case in hand here, where essentially the advice based upon Sharia law that the court was given, which then affected the judgment of not to enable the Bart's Medical Trust to Health Trust to end the life support of the child in question. Were this to be a family in the United Kingdom who, say, didn't have religious beliefs but similarly wanted the same outcome, and then because they didn't have, this is what a church says, this is what a temple says, this is what a synagogue says, this is what a mosque might say, and there was a different outcome to that case, would that be fair?
Well, first of all, these cases crop up quite regularly in the UK. They're very sad cases. They happen regularly. Sometimes the parents are religious. Sometimes the parents are not religious. I haven't gone through all the cases. I have gone through this one. I said I quickly went through all 70 pages. And my view from reading that 70 pages very quickly is that the fatwa played basically no meaningful role in the decision.
Mohammed, thank you ever so much for joining me. And that was Mohammed Amine.